let's talk about our separate property template. So almost every case, divorce case, has separate property. Sometimes it's just furniture they've inherited from their family, or their wedding ring certainly is separate property. Gifts of jewelry, that's very common. And those are simple, right? It's a gift. They testify it's a gift, whatever evidence they have of gift. But some separate property is much more complicated. And so we've built a template for the more complicated separate property issues to help you both to think through how you approach it and to give you some supporting law. So one is the whole arena of arguments of gift of real property. And it could be any type of titled property, but let's use real property as an example. There is a presumption that when you title something in someone else's names, that you're gifting it to them. So let's say that prior to the marriage, my client had the house as his separate property, but during the marriage, he retitled that house into both parties' names or the other party's name. Well, there's a presumption by retitling it that he has now made a gift to her. And this area of law, and I'm going to go into it in more detail, it's really complicated, so you want to look carefully at the case law. And the case law isn't all on the same page, which makes it more complicated, of course. But you want to definitely look at the face of the titling document, because it could have a statement of that this is separate property or community property. It could have a statement on the face of it itself, and that's going to affect your situation. But let's just say, for purposes of our conversation, that it doesn't have any explicit language. It just has retitled it into the party's name. So now the property is listed in both of their names. So that's a presumption. Now, presumption doesn't mean game over, right? It's just a presumption. And there's law about how do you overcome or rebut the presumption. And we have in here, in more detail than we're going to talk about, we're just going to alert you to it. What some of the cases that talk about how do you rebut that presumption. And where it gets really confusing is, do you get to use parole evidence? In other words, does someone get to testify that they had no intent? Because intent is really where your rebuttal is going to come in. There was no intent to make a gift. That's the statement. We had some other reason for retitling, and it wasn't gift, there was no intent, because you have to have intent. Well, how do you show intent? Are you allowed to have oral testimony and come testify? I never meant to do that. Well, sometimes you're allowed to have parole evidence, many times you're not. If it's explicit on the face of the document, there's a lot of case law that says you do not get to have parole evidence. Well, that obviously would make it difficult to rebut it unless you have another document to support that you were doing something else. However, there is case law out there in some unique circumstances where parole evidence has been allowed. As an example, there's one case where there's a convoluted estate planning going on from one generation to another, and that is one of the reasons that it wasn't a gift. It was really part of this convoluted estate planning. And the transfer wasn't really from spouse to spouse. It was from one of the spouse's parents to both spouses. So then they were arguing gift. Well, that case distinguished itself from the rest and said, because it's not spouse to spouse, parole evidence is allowed. So you want to be very careful and look closely at the case law. Don't rely on one case. Look at all of it. Especially if the first case you find isn't going the way you want. There's probably one that supports your position. The appellate courts are a little bit not in sync on some of this. So I would look at that. Now, tracing still applies. So despite all this, presumption, rebutting presumptions, tracing is still relevant. So you definitely want to do your tracing and see if you can trace the money path, because that might affect what you're arguing. So there's some complicated, I want to make you aware that there is some complicated rules about all of that, and this template will help you to dig through all of that. So this is our separate property template.